Good evening, everybody. We're starting our traditional webinar of United for Ukraine Network. My name is Andrius Kubilius. I'm a member of European Parliament from Lithuania and also coordinator of this network, United for Ukraine Network. And those who are participating in our webinar, perhaps not the first time they are participating, they know how we are doing those important webinars. Today we have a very important, interesting, and challenging, I would call, webinar on the topic, which sounds very, I would call, legalistically, countermeasures, international law, and the confiscation of Russian state assets for reconstruction of Ukraine. And we shall have two really brilliant speakers. Professor Pierre Klein, co-author of one of those legal memorandums on that topic, which I will try to very briefly to explain. And he represents Center of, or he is active in Center for International Law, University Libre de Bruxelles, and also my colleague, member of European Parliament from Poland, Władimir Cimoszewicz, former Prime Minister of Poland, former Minister of Foreign Affairs, but also former Minister of Justice and also former Attorney General of Poland. So, and lawyer by education. So, and very big promoter of those ideas on how to use countermeasures for seizing Russian frozen assets here in European Parliament. Why we want to discuss that topic? My very brief political explanation, of situation. As all of us we know, European Commission, after long discussions on how to use frozen Russian assets, which amount up to 300 billion, mainly assets of Russian Central Bank, is coming to some decision, to some proposal, which we hope will be announced next week. And that proposal, what we call proposal based on windfall taxes legal instrument, is the first step. So we consider this is positive. But at least what we see from Commission forecasts, it will generate per year only around 3 billion euros, which from one side looks like quite a big amount of money, but from another side, when all of us we know that according to last World Bank estimations, the damages to Ukrainian economy inflicted by Russian aggressive war is more than 400 billion. So 400 billion and 3 billion is difficult to compare. And that is why definitely there is a need to look into also other possibilities and legal mechanisms, how those Russian frozen assets can be seized and used for reconstruction of Ukraine. I will not go into all the legal details, but really what is important, we started to discuss possibility to have a special debate in European Parliament, maybe next week, maybe in January, and exactly at that moment when we started to discuss among ourselves how we can proceed, the best, I would call, international lawyers, the whole group of them, including Professor Pierre Klein, who is participating today, and also such names like Philip Zelikov, Professor Philip Sands, all others, produced a so-called legal memorandum. It was published on 20th November of 2023, which speaks about, in a very clear legal language, about what is called countermeasures instrument, which in such circumstances as we have now with aggressive Russian war against Ukraine, as I understand from all the legal arguments, is really possible to be used and possible to seize all the money which now are frozen and to use them for Ukrainian reconstruction. So, in short, this is where we are now, and I am very happy that today we have one of the authors of this memorandum, Professor Pierre Klein. And I would be very happy if really, Professor, you would explain us not only to those people who, like Volodymyr Shimoshevich, are, lawyers by education and by their background, but also for such, persons like me, who my knowledge about law is very, how to say, only from political job. I came from physics, so that's what I need to confess immediately. But it would be great to have from you clear explanation what is that instrument about, and what is the difference in between of what you are speaking about and what are legal worries of some institutions who are still not moving into that direction, but which perhaps we can try to convince them to go ahead. So please, and before you will take the floor, I would remind all the audience that, as usually, you can put your comments or questions to both speakers on chat, and then I hope that we shall have also enough of time to discuss after initial presentations. So, Professor, please, floor is yours.
Thank you very much, and thank you for giving me the opportunity to present the memo we've produced with colleagues from various number of countries in Europe, but also beyond the US, Japan, Kenya. We are the authors, mainly professors of international law in various institutions and practitioners of international law in those various countries. And as you said, the main argument we are trying to develop in the memo is to explain that it would be legal. In our understanding, it would be lawful under international law to use the confiscate the assets, the Russians' assets that have been seized by a number of countries as a consequence of Russia's aggression of Ukraine, to use them in order to provide reparation for damages caused by the war. The legal justification, as you suggested, for such measures would be the theory of countermeasures. What are we talking about here? Basically about acts that are on their face in contradiction to law. They are unlawful as such, but because they respond to an initial wrongful act, an initial breach of international law by another state, they are seen to be lawful because they constitute a response to such an act. So it's basically the same mechanism which is at play here than the one that may be found in many domestic legal orders or in the law of contracts in many countries, for instance, under the appellation of exception of non-performance. Very simply, if you buy a car, you are supposed to pay for the car, but if the car which is proposed to you doesn't meet the specifications that were agreed in the initial contract, you are under no obligation to proceed to payment. That's basically the same mechanism that applies, that comes into play in international law. It certainly does come into play in the law of treaties, for instance, the non-performance of a trade treaty between two states, but also beyond such a situation. In fact, we could certainly argue that the freezing of Russian assets, which has been implemented by a number of states and actors, could, to a large extent, be justified as a countermeasure. Now, countermeasures are an institution which has been rather heavily debated in international law for quite a while. Why is that? Because countermeasures, in a way, are an institution of what we may call private justice. They enable each state to make a judgment as far as the implementation of international law by other subjects is concerned. Each state will make its own determination in that respect and decide that, in this case, if the other state does not comply with its obligation itself, it is allowed not to comply with its initial obligations. The conditions for countermeasures have been enunciated in the instrument, which is the reference when it comes to state responsibility in international law. We are not talking about a treaty as such here, but about an instrument that looks very much like a treaty. It is the product of the work of the United Nations International Law Commission, which is an organ that is tasked with the development, progressive development and codification of international law. And the ILC did such work regarding state responsibility over a number of decades and came up in 2001 with a set of articles on state responsibility, which is considered to be largely authoritative when it comes to enunciating the rules applying to state responsibility. And those articles indeed enshrine the principle of countermeasures, even though, as I said, they certainly also enunciate a number of conditions to be met for countermeasures to be properly applied. The first one certainly is the initial breach of international law by the party, the state against which countermeasures are targeted. In our case, it certainly is beyond dispute that the invasion, the continued aggression and occupation of significant parts of Ukrainian territory by Russia is a breach of international law. It is beyond that a breach of the most fundamental norms of international law concerning the prohibition of use of force and respect for sovereignty. There have been broad condemnation, including by the UN General Assembly, as you know, on no less than 3 different occasions since February 2022. The countermeasures have to be taken by a state which has been injured by the unlawful act, but they may also be taken by states beyond directly injured state if the obligation which is breached is what is called an obligation erga omnes. What is meant by that is that we are talking about obligations which are deemed to be of such fundamental importance for the international community or society of states that every state is deemed to have an interest in reacting to such a breach. Whether third states could, in such situation, in situations of breach of those obligations erga omnes, also take countermeasures has been a matter of controversy for some time, but there is evolving practice in that sense. There is a resolution which has been adopted by the Institute of International Law in 2005 that explicitly asserts the right of third states to take forcible countermeasures in situations involving breach of such norms. So we may say that the second condition is also met in our case. The purpose of countermeasures, it's clearly defined. It is to induce the responsible state to cease the wrongful conduct and also to comply with obligations such as the obligation to compensate states or other entities which have been injured by the conduct. So that would be the case in a situation as well. There is, in addition to that, conditions relating to proportionality but also to reversibility. The idea, as I mentioned it, is definitely to induce the responsible state to modify, to change conduct, and to provide reparation ultimately. So the countermeasures have to be in proportion with that aim. They cannot have a far wider impact than what is necessary to achieve this aim. And that, again, certainly could said to be the case here. When it comes to this notion of reversibility, countermeasures are conceived of as being of a temporary nature. The aim is to ensure a return to legality, to the application of international norms. And when this purpose is achieved, countermeasures have to come to an end. So if we were talking simply about exercising pressure on Russia to stop current international breaches of international norms, such as the continuing use of force or continuing occupation of territory, you may say that indeed the measures should come, the countermeasures should come to an end as soon as Russia complies with that. But let's keep in mind that we are talking about something that goes beyond that here when we are talking about the obligation to provide compensation. This would mean that this reversibility requirement would apply in a different way somehow, because the obligation to provide compensation, when it is executed, is itself definitive. So the fact that the assets would be confiscated and that would also be a definitive measure does not come as an obstacle in our situation. There are, in addition to that, more formal requirements, such as giving prior notification to the state which is targeted by the countermeasures, in order to make it possible for that state to comply ultimately with its obligation before setting the countermeasures in motion. So our vision, our argument is that indeed all of these conditions are met. It is not to say that there are not a number of issues that would arise if countermeasures involving the confiscation of Russian assets were put into place. There may be a number of issues from an economic perspective, from policy perspectives, and so on. But what we are saying is basically that from the perspective of international law, such measures would indeed be justifiable and defensible. So that's basically, in a nutshell, the argument we are making, and I will, of course, be happy to respond to any questions you may have on those different issues and requirements. Thank you very much.
Thanks a lot, Professor. Thanks a lot. And now, without any delay, I will ask my colleague, Member of European Parliament, Vladimir Shimoshevich, to make his statement. And again, I can remind that Vladimir is one of the most proactive members of our own parliament on this topic, how to seize Russian money, and he was arguing for similar approach for quite a time, and I think that we're really coming to some formal discussions in the European Parliament. But Vladimir, please, how you see the whole situation?
Thank you very much, Andrius. Let me take this opportunity to express my gratitude to Professor Klein as one of the authors of that analytical paper called Legal Memorandum he presented, that you talked about starting our meeting. This truly very high quality legal analysis, and as Andrius already mentioned, very clear. It can be read by non-lawyers and, of course, understood since arguments are very clear, very convincing. When that phase of Russian aggression against Ukraine started, full-scale war, full-scale aggression, there was a need to answer at least two questions. First, how to stop Russia, and then how to help Ukraine. And as a reaction to the aggression, one of the decisions taken by Western democratic countries, including European Union, were sanctions, and was freezing of Russian assets, both state-owned as well as private. And despite the fact that it was not called that way by anybody, in fact, that was a countermeasure. Otherwise, if that was not the reaction for the aggression, it would be an illegal act. But that was fully legal, and we should not be, let's say, even thinking that we could do something against the law, against the legality. That was a legal act. In case of Ukraine, of course, first of all, there was an urgent need to help Ukraine and Ukrainians who had to leave their homes, even leave their country. I am from Poland, as Andrew said, and as you probably know, there were millions of Ukrainian refugees who got also to my country. Then there was a need understood better and better by the Western countries to supply Ukraine with various kinds of equipment, including military, including arms. We still remember those discussions, phases of discussions, what kind of arms, lethal arms or not, long range or not, etc., etc. Step by step, we were moving, in my opinion, right direction, trying to equip Ukraine in arms needed to defend itself successfully, or even to defeat invasion aggressors' army on the territory of Ukraine. But that is, of course, not the end, because already now we have to think about the future. War will end one day. Let's hope that rather sooner than later. But then there will be a problem of reconstruction of Ukraine. You, Andrews, mentioned that estimate made by World Bank, but it was presented in February this year. So just after a year of that phase of aggression. And that, of course, the scale of the damage is growing every day. Nobody knows how much it will be finally. But we are talking about a very, very big sums of money, very big. And we need a realistic answer how to finance reconstruction of Ukraine. In my opinion, we should also understand that reconstruction will be not only an enormous endeavor, but it will be also a very urgent task. Why? Because, first of all, millions of Ukrainians deserve to live in more or less normal conditions. But then, let's imagine the situation of that people, of that nation, when probably hundreds of thousands of veterans come back to the cities, the villages, and a lot has been ruined. There are no factories, there are no plants, there are no places where they used to work. And what those people, mid-age and young people, will have to do. It could be a humanitarian catastrophe. It could be political catastrophe. It could be also, it could bring also other very, very negative consequences for Ukraine as a country, but also for our countries as neighbors. We probably all remember or know what was the consequence of Soviet engagement in Afghanistan after return of veterans from Afghanistan to Russia. What happened in the 90s with those people. But then there is a problem of, let's say, of justice. What is and what should be done to, let's say, secure our right to speak about values, to speak about rule of law, to speak about the world we are living in, and would like to convince others to live according to the similar, let's say, principles and values. That should be understood. This is not just a material problem. This is also political, this is mental problem, and so on. Can we imagine a situation when, after that bloody, terrible war, with hundreds of thousands of casualties, so one day we return Russian state-owned money to Russia? Can we imagine that? Well, what we will think about ourselves and our understanding of the situation? What will be the reaction by the Ukrainian people to that kind of decision? From almost the very beginning of that war, especially when it became so evident that it is, let's say, very costly. I mean, the damage is done by Russians is enormous, is huge. I thought about what can be done with that Russian money frozen in the West, especially state-owned money. I don't want to go into the details, but I believe that freezing of private money belonging to so-called oligarchs is a different story, and I personally would rather focus on what to do with big state-owned assets than much smaller sums of private money because of possible trials, court trials, etc., etc. Many months ago, in some of our discussions here in Parliament, I mentioned the problem, the idea of confiscation. In that time, there were not many colleagues believing that it could be legal, since at the very beginning we could see a lot of comments saying that due to the fact that those assets are protected by sovereign immunity of the state, it cannot be done legally. There is, I believe, lack of understanding of the legal situation. Russia as an aggressor, violating the most fundamental norms of the current international law, is not protected by that immunity. And its property, it's not protected by that immunity. The Russian asset can be confiscated. And in my opinion, there are two possible ways of legal confiscation. One described by Professor Klein and common paper, countermeasures. And the second one is use of Article 51 of the United Nations Charter, self-defense, the right to self-defense. UN Charter provides two possible variants, ways of using the right, individual self-defense against invasion or collective. And any country asked by a victim of aggression can help that country, can help the victim, offering whatever is needed to stop aggressor, to defeat aggressor, including even the most radical forms of assistance, like sending military personnel to the attacked country to help its military forces to defend the country. There is one of the simple, let's say, principles of law. If you can more, you can less. If we can, answering requests from Ukraine, send our even troops, risking, of course, war between us, I mean, NATO and Russia, from the legal point of view, not from the point of view of common sense now. If we can do that, we can do less. We can supply Ukraine with arms. We can support Ukraine other ways. We can confiscate Russian money as a way to decrease Russian ability to continue the war, to weaken Russia. And that, in my opinion, should be done, and it should be done rather earlier than later. That is very good that we are talking publicly about that issue, about that problem now, since, as we know, in coming days, we probably can hear from the European Commission what are the ideas, what are the proposals by the Commission. We of course, informally know what they are thinking about. It's not sure that they will confirm that publicly, but they don't think about confiscation of assets, but rather confiscation and transferring to Ukraine profits and from investing of those Russian assets. And as you mentioned, Andrius, there's of course no, let's say, proportion, rational, acceptable proportion between the needs and the money achieved that way. On the one hand, we are talking about hundreds of billions of dollars. On the other hand, we are talking about a couple of millions of dollars or euro a year. It's nothing. From the legal point of view, in my opinion, the situation is absolutely the same if we confiscate the assets or we confiscate the profits from investing those assets. And I'm even, let me say that very frankly, I feel to be ashamed that legal services of the European institution, of the European Commission, say that there is a difference, that there is a significant difference. That is why they are going to propose to confiscate the money, the profits instead of the money. So it can be done both ways. It can be done both ways. I would like to just add one more comment on the proposal included to that legal memorandum. The idea of creating international mechanisms for compensation as a kind of body institution collecting Russian frozen money transferred to that body, and body responsible for distributing it, transferring it to Ukraine mostly, but probably also to some other countries or entities that suffered from the war or consequences of war, or from the illegal decisions made by Russian authorities, like confiscation of the property of the companies from our countries. This is a very bright idea, I believe, because it would make it easier for countries who control frozen assets to transfer them. They will do that in relation with international body, which can be created by a collective decision of the group of the countries, rather than to directly to Ukraine. And it politically, I believe, should be easier for them to do that this way. And then such a body can be, well, let's say, controlled. The rationality of decisions about transferring money to Ukraine, etc., can be guaranteed. So I have no doubt that from the legal point of view, confiscation is possible. I have no doubt that from the point of view of the situation of Ukraine and in Ukraine, it is absolutely necessary. And unfortunately, I have no doubt that what is between us and that goal, these are political, let's say, deliberations, arguments in favor or against, not neglecting those arguments which sometimes are being presented, political or financial ones. I do not think that they can be treated as equally important as legal arguments presented today. Thank you.
Thanks a lot, Vladimir. So, as not a lawyer, I will try to make one small comment, and maybe additionally to ask to additional explanation. But thanks a lot both to Professor and to colleague Vladimir Shimoshevich. You put very clearly arguments on legality of countermeasures legal instrument. But as at least while we were following all the debates in Commission, and when we were looking into Commission proposal arguments, how they were putting, always there is one legal argument and one financial argument. So legal argument is that state property has international legal immunity, and that because of that, you cannot touch Russian frozen assets because this is a state property. I understood, and especially from your legal memorandum and from different articles, that in, let's say, in the nice, peaceful times, that is a reality. You cannot, let's say, take another state property in any kind of legal, arguments. But my question is very simple. Am I correct that really this argument is not valid when you have the war situation and when you have one country which is making, huge damage on another country? So then you can use countermeasures, and this, argument on immunity, legal immunity, is not anymore valid. Very, very clear, simple point. Because then another argument, I can again elaborate just few sentences, but let's not forget the first question now. Another argument which you can see everywhere now in Commission discussions and also in the different articles which are published about Commission proposals, that there is what we can call financial arguments against using against seizing Russian frozen assets, and those financial arguments were presented by Mrs. Lagarde, President of European Central Bank, which we have said, and that was repeated by somebody else, that seizing of Russian frozen assets can destabilize international reliability of US dollar and euro. But that is very well answered by such prominent, international experts and grand experts like Larry Summers, who was Secretary of Treasury in the United States, Robert Zoellick, who was President of World Bank, who, together with Philip Zelikow, earlier in July, perhaps, published a very powerful article in Foreign Affairs. So again, this financial argument, as I understand, also is not of a very big value. But this, again, legal argument. I am correct that really, if Commission is saying that they cannot move into countermeasures because there is this legal immunity, that is not a correct argument. So, Professor, yeah.
Yes, my answer would definitely be yes, indeed, that immunity from execution would come into play. It extends protection to state assets as such. But the idea of countermeasures is precisely to justify a breach of an obligation. In that case, the obligation to afford protection to state assets. So yes, there would be a breach of state immunity from execution, but the breach would be justified on the basis of the countermeasures theory. So that's the simple answer I think that can be made on this particular question.
Good. We have, and I will maybe add also, we have one question from our good friend, Mark Demesmaeker, who now is serving as senator in Belgium Parliament. Before that, he was member of European Parliament and very active member of our United for Ukraine network. And of course, since Belgium keeps 200 billion frozen assets, he's looking really what will be the Belgian responsibility. And the question is very simple: the international mechanism, what Vladimir was saying from your memorandum, through which the states concerned would transfer Russian assets. Now, is it yet to be established?
Yeah.
It's not existing, and by whom and how?
Yes. Before I turn to that, I would just like to add something to what I said just a minute ago, is that I'm in complete argument with Mr. Timošević regarding the confiscation of the products, the interests that have been produced by the sums. I personally fail to see a difference of legal justification, because obviously the interests that are produced by sums are also the property of the owner of the asset. And in legal terms, I don't see a difference between both. So if you can argue that indeed you can rightfully confiscate the product of the amounts of the assets, I personally see no difference between justifying that and justifying the confiscation of assets themselves. Now, turning to the question of the mechanism in question. This is something which has been actually referred to, or even one may say suggested, by the UN General Assembly in its resolution of November 2022. I quote from paragraph 4 of the resolution, the General Assembly recommends the creation by member states in cooperation with Ukraine of an international, that was for the International Register of Damage to serve as a record of evidence and claim information on damage, loss, and injury. So that's an important step in the process because it's a way to register claims and damages on the basis of which compensation could then be awarded. But before that, in the previous paragraph, the General Assembly also recognizes the need for the establishment, in cooperation with Ukraine again, of an international mechanism for reparation for damage, loss, and injury, and arising from the internationally wrongful acts of the Russian Federation in or against Ukraine. So this is not something we personally came up with. It's rather the suggestion made by the General Assembly itself. So it should be established either by the General Assembly as well under the same legal basis, which is the Uniting for Peace resolution, or by a group of states willing to establish such a mechanism. Now, we got a clear blueprint for that because we can turn to the most significant precedent in this area, which is the UNCC, the United Nations Claims Commission, which has been established by the UN following the invasion of Kuwait by Iraq in 1990. And this body has been working for a number of years after Iraq withdrew from Kuwait to examine, assess all claims and award compensation to the claimants, using for that the funds which had been initially frozen and then confiscated, coming mainly from the proceedings of the sales of Iraq oil. So that's certainly something we could draw inspiration from in that respect.
Okay, I see some interesting
questions.
May
I add something? Yeah. That example presented by Professor about that body established after Iraqi aggression, invasion of Kuwait, there is a difference because, of course, in that time, Security Council condemned that invasion unanimously. So with the support of 5 permanent members, we cannot expect that this time. And of course, I believe that there should be no problem with the kind of political support from the majority of the General Assembly of the UN. But I think that easier and faster, if there is a political will, of course, procedure would be to create a special body, special organ, international organ by a group of countries, especially those who control Russian frozen assets. But it would be better, again, in my opinion, if the group of the countries is broader. Because if they create that kind of international mechanism, then let's say responsibility for confiscation or responsible for the way the money will be used will be collective, will be shared by a bigger group of the countries. It will be, let's say, stronger solution. And if one day there is a group of the countries ready to go this way, to use countermeasures or collective security, I would suggest to make it that way. Something between, let's say, global solution recommended by the General Assembly and something, a very narrow, I mean, the group of the countries controlling Russian money.
I have several questions. Maybe I will try to very briefly to announce them, and and then maybe you will be able to answer. First of all, Victoria Kerr is asking, in general, very, very important question. where the money, seized money, should go. Only to reconstruction and reparations, or also to survivors, and then using some kind of existing mechanisms. For example, in collaboration with Ukrainian state, to use the ICC Trust Fund for Victims, the compensation mechanism which will attach to the register of damages in the Global Survivors Fund. I don't know about those very specific instruments, but the question is, how should be then, those money distributed? To go, to reconstruction, or to look also to personal, damages, personal victims. That is one thing. Second is, if you will, Professor, if you will jump in immediately, I see from Mark Demesmaeker, again, questions. They had debate yesterday with the Prime Minister, Belgian Prime Minister, and Prime Minister is saying that he is in dialogue with European Commission, and he wants to act only in consultation with Commission and G7. And his concerns are legality, but also warning of central bank, of financial system and euro stability. So we are leaving finances, for perhaps for Vladimir, we shall need to have another, webinar, asking some kind of financial, experts to explain why those concerns are maybe not so big ones. But the question, and my question, what I would add to Mark Demesmaeker, what kind of decision, EU or you should suggest, for EU to start implementation of this, countermeasures? Should it be EU level, some kind of directive, or simply recommendations for different states like Belgium, to use a legal mechanism, to have special law, and with support of EU, but to move on their own? So two questions mainly.
Well, regarding the first one, it will definitely be a political decision to be taken by the authorities that are going to set up the mechanism in question. How is it going to work exactly? Which are going to be the priorities? Which type of claimants are going to be considered in which order? Again, so that's all for political decision makers to decide. Indeed, there are a number of options in that respect, and why not indeed use some of the mechanisms as the one you suggest, the ICC Trust Fund. That could be a way forward, but it will be for the decision makers to see that at that later stage. Regarding the other question, as you mentioned it has to do to a large extent with other type of implications, like economic implications. In particular, you referred also to what Mrs. Lagarde was saying in that respect, and that's not something I'm really qualified to have a say about, I'm afraid.
But my question was also about what kind of, how implementation of, if there is a political will to start to implement, countermeasures. So should it be national law by Belgium, for example, by other countries which have frozen, or should it be some kind of EU level directive, or some kind of such kind of legal instrument used?
I would tend to say that a collective decision and collective process would probably be preferable in this area, and therefore I would tend to turn to the second option rather.
Mm-hmm. Okay, well, Zimmer, would you add something on those two questions?
Yes. First, how the money should be used. Of course, that should be decided with close consultation with Ukrainian authorities, Ukrainian government. Of course, the countries transferring money to that international mechanism, and the body or authorities of that international mechanism should also be allowed to use various expertise, telling, suggesting what would be the best way to spend that money in the future, and so on. It is not about just simple reconstruction of Ukraine, reconstruction of damaged infrastructure, houses, buildings, bridges, etc. But of course, that whole idea of reconstruction, Ukraine should be treated as an opportunity to modernize Ukraine. And we should also think about the process of preparing Ukraine for the future EU membership. And probably that money also could be used in that purpose. The decision about creation of that mechanism, international mechanism, should be taken by the countries which will fund, which will transfer money, as well as some other, but not by the institution, but by the group of the countries. International law allows countries to adopt, to sign any agreement which corresponds with the legal possibilities. And as we said, and we proved, it is a completely legal way. But if I may, Andrews, I see a question from Darius Zilis on chat.
Yeah, exactly. I was ready to ask that. And please go on.
Yes, how all that idea correspond to the requirement of reversibility and limited in time countermeasures. That's very easy, and Professor Klein already spoke about that. The violation of international law by Russia, this is not just sending an army and fighting and bombarding, shelling, etc., but it is also occupation of Ukraine territory. Until the last Russian soldier will be deployed on Ukrainian territory, understood as the territory within the international recognized borders. So from 1991. That will, until there is one Russian soldier, that will mean that Russia continues to violate international law. And that will be that kind of time perspective when countermeasures can be used. And reversibility, again, that's easy. Russia is legally obliged to compensate the damage done to. And we already today can say that even with confiscation of 100% of Russian state-owned assets in the West, we will still not have at our disposal sums equal to the needs. So when let's be optimists that one day there will be the way to either convince Russia to pay more or to find a way to get more Russian money. What will be used as a countermeasure, I mean, confiscation, should be deducted from the overall sum needed to compensate Ukraine 100%. Thank you.
Professor, would you elaborate on that? Yeah, please.
Yes, maybe a small addition to that. As I said, the basic purpose of countermeasures is to induce the target state to comply with its own obligations under international law. In that case, specifically, the obligation to provide compensation. So let's now imagine that simply because Russians' assets have been frozen in the West, that by some miracle in a way is enough to convince Russia to provide reparation, and Russia, in that hypothetical scenario, uses other assets at its disposal to offer compensation. Then, in such a situation, indeed, what reversibility would mean is that as soon as one can say that Russia has fully complied with its obligation to provide compensation, the freezing of assets should stop, provided, of course, that the other condition relating to the use of forced occupation of territory and so on is also met. But let's focus on reparation, compensation. As soon as this obligation is indeed satisfied, the measure should come to an end. And therefore, there should be a unfreezing of the assets in question. Now, we know that this hypothetical scenario is not going to happen. So basically, the idea is that we sort of reach the same result, but by using the countermeasures theory. And indeed, the ultimate result is that we go back to the full application of international law. We go back to the initial relation between the subjects as it was before, okay? And this is because, of course, of the very particular nature of the obligation to provide compensation, which is in itself definitive. Once you have provided the money for compensation, then the aim is achieved. And so that's why I was saying earlier that this requirement of reversibility does not, in such a situation, when it comes to providing compensation, does not apply in the same manner as it does for other obligations under international law. I hope that this makes things a bit clear in that respect.
Well, thanks a lot, Professor. And our time really, is coming to the end. I would like to thank you very much, really, from all my heart. I think that really it was very important, discussion, and all the arguments which you presented, both Professor Pierre Klein and our colleague from European Parliament, Vladimir Shimoshevich, is really all those arguments are very helpful for us. I think that all those who are in some way hesitating because of some kind of legal language or legal arguments that countermeasures are not possible to use, they should be convinced by what you were speaking out and what you wrote in your memorandum. So that's very, very clear. We shall use your arguments in our plenary debate. And of course, still there are those financial or monetary arguments, but I think that with Vladimir, we shall try to find also the same level of experts who will explain very clearly that it is not such a danger for international standing of euro or US dollars. And that is why I hope that really we shall be able to make an impact, positive impact on decisions which are needed to be done in order to really to push that very important mechanism, justice mechanism, I would call, and definitely which would allow to achieve what everybody is speaking around, especially Ukrainians, that Russia must pay. Russia must pay, and that is what we need to do. So thanks a lot again. Thanks very much, and let's keep in touch, and let's be ready for next steps in that direction. Thanks a lot.